We'll hear the first two and then take a brief recess and then finish the docket. And we begin with Cuenca-Arroyo versus Garland. Mr. Bray.
Good morning, Your Honors. May it please the Court. My name is John Bray, and I represent the petitioner in this case, Mr. Cuenca-Arroyo. This case presents a question concerning judicial review of immigration cases. What are the courts to do when there are questions of law embedded within discretionary determinations? Or, to paraphrase Justice Gorsuch's dissent in Patel versus Garland, does the decision in Patel block review of any clearly erroneous determination under the guise of discretion? Now, I would propose that in arguing that judicial review of erroneous legal conclusions survives Patel, I would propose the following. First, we would contend that the agency committed legal error in this case in concluding that Mr. Cuenca had committed tax fraud in the context of a discretionary analysis because that is a legal conclusion. And second, and more importantly, we would contend that this court has jurisdiction to consider such issues. Now, I would note, just from the get-go, that the United States Supreme Court recently heard oral argument in the case of Wilkinson versus Garland, and that decision may well have an impact on the outcome of this case because that case dealt with similar issues relating to the court's authority to review hardship determinations in discretionary immigration cases just like this one.
As you probably know, our usual course of action there is that we do our thing and they do theirs, and if they come up with something that we need to abide by, of course we will.
Yes, Your Honor. Yes, Your Honor. Now,
Can I ask you a quick question?
Yes, Your Honor.
The Supreme Court in Patel, which you've already referred to, instructs us to read 8 U.S.C. 1252A2BI broadly because it uses the language, any judgment regarding the granting of relief. Why is a continuance not one such matter?
Well, Your Honor, I would actually refer to my co-counsel, Yadira Juarez. She'll be presenting on that issue. Okay. But it would be my contention that that would not be subject to, that would be subject to judicial review.
So you're presenting on what specifically, and what is she presenting on, so I don't bother you with the wrong questions again? I'm sorry.
Oh, no, it's not a problem at all, Your Honor. I'm presenting on the issue of jurisdiction as it relates to, why this court has jurisdiction concerning tax fraud. And then Ms. Juarez will be presenting on the issue of, whether, this court has jurisdiction over the continuance.
So she's only doing the continuance?
Correct.
Okay.
Yes. Now, there are a number of facts in this case that were not disputed, and in the interest of time, I won't review them, but I would like to highlight one fact which I believe is important for today's discussion. And that is that Mr. Cuenca did submit federal income tax returns for several years, but the IJ concluded without explanation and without citing to any relevant legal authority that these returns reflected that Mr. Cuenca had committed tax fraud, which again we contend is a legal conclusion subject to de novo review.
So why would Perez v. Garland not apply here?
I'm sorry, Your Honor?
Perez v. Garland, which holds that 8 U.S.C. 1252A2BI bars us from reviewing the challenge to the hardship determination regarding cancellation of removal.
Well, Your Honor, I think that the issue here really is that if this was denied as a matter of discretion, but if that discretionary determination was based on an erroneous legal conclusion, then this case would be denied anyway. And also the discretionary analysis impacts both the determination as to cancellation of removal under Section 1229A, as well as to voluntary departure. So, and as to the issue of hardship, the hardship was the one thing that the IJ did, discuss in the case, in the decision as being the reason why the case was denied. But even though he said that, the IJ also got to the issue of discretion and said, essentially, even though I don't reach those issues, the issue of discretion for the purposes of cancellation of removal, I do reach that issue for voluntary departure. So essentially, it would have resulted in the same decision.
Right, but the BIA would have denied regardless. So the tax fraud discussion is not necessary to the denial of voluntary departure, is it?
Well, Your Honor, the issue of discretion was based on, overwhelmingly was based on the immigration judge's conclusion that my client had committed tax fraud. That was the overwhelming negative or adverse factor.
When you say committed tax fraud, are you speaking of that in terms of some criminal conviction? Because there was no criminal conviction here
That's right, Your
as
Honor.
a result of what happened with immigration.
That's right, Your Honor, and actually that goes to my second point here. There was no criminal conviction, there was no civil penalty assessed, there was nothing like that. Instead, the issue is, although I think that the immigration judge certainly phrased it like that and framed it like that. In fact, he even called my client's tax preparer a co-conspirator. But inexplicably, this was, there was no conviction for tax fraud. I would also like to note, Your Honor, that the immigration judge's legal conclusion that my client committed tax fraud is at odds with the substantive tax law. Publication 501 for tax year 2017, in fact, details who qualifies as a qualifying relative, who could be a dependent for tax purposes, and that includes nephews, in other words, sons and daughters of a person's brother or sister, and that also includes people who live outside the United States, specifically people who are residents of either Mexico and Canada. And the record is clear that that is what happened. My client's nephew was the named dependent, and he did live in Mexico. The judge found that that was tax fraud, but that's at odds with the law.
But he said he was sorry and that he apologized for so he thought it was wrong, but continued to do it, even after the BIA proceedings. So regardless of whether technically it could be excused, he admitted culpability and said he would stop it, and he didn't. So why isn't that alone? He didn't say, oh, this is technically a correct thing under the tax law,
Your Honor, I would submit that my client believed the immigration judge when the immigration judge pointed this out as an instance of tax fraud, because my client also stated that he did not know the tax laws. So he assumed, well, maybe my tax preparer must have made a mistake, but he was entitled to rely on his tax preparer's legal advice, and the United States versus Boyle was...
And is there any evidence in the record that his tax person gave him advice after he had already been told that because the person lived in Mexico, he could not claim him as a dependent, and he had already admitted he was going to stop doing that? Is there any evidence that he got further advice and that was okay or something, and he then told the government, I'm not going to stop this. I'm going to keep doing this because it's okay? There's none of that in the record.
Well, Your Honor, I would note that there's nothing that goes directly to that point. However, there was uncontroverted evidence, number one, that my client used the same tax preparer for a number of years, and number two, the immigration judge in this case, and this is also a key distinction between this case and Patel versus Garland. In this case, the judge found Mr. Cuenca generally credible, and again, because of the fact that he was found credible, the fact that he was credible is not reviewable by this court. So he was deemed credible by the immigration judge, yet incongruously, at the same time that he was found credible by the immigration judge also concluded that he was somehow guilty of tax fraud. There's also, the record is also void of any referral for criminal prosecution for tax fraud or referral to the IRS for any sort of assessment of civil penalties.
But whatever he called it, that determination resulted in a voluntary departure. He doesn't challenge the voluntary departure.
It resulted in the denial of voluntary departure.
Yeah.
Right, so if the immigration judge had agreed that, if he had found that my client deserved voluntary departure as a matter of discretion, then he could have reached that issue, and presumably he would have reached that issue in the context of cancellation of removal as well. But essentially the way that I would propose that this should work is that, essentially you've got two categories of cases. You have cases that fall under the guise of Patel versus Garland, for which there is no review because it involves a factual dispute. And then you've got other cases, such as this case, I would propose, that fall under the guise of Guerrero-Lasprilla, and those cases are reviewable because they involve the application of a legal standard to undisputed or settled facts. Again, we don't challenge any factual determinations here. We merely challenge the legal conclusion that my client committed tax fraud.
Okay, what about the DWI? Because the government says it's harmless error under Delgadillo versus Holder.
Yes, Your Honor, and he did commit DWI, and he admitted to that, and we're not challenging that determination. He did commit DWI. However, I would contend that this is not harmless error, or rather the harmless error doctrine does not apply, where there is an error in where the error in question affected the substantial rights of one of the parties. And for that proposition, I would cite to, well, for example, Federal Rule of Civil Procedure 61, and also McCandless versus United States 298 U.S. 342, a 1936 case. The substantial right affected, specifically in this case, is the fact that persons who are seeking discretionary benefits for immigration relief are entitled to analysis of that case in a manner that substantially comports with law. And again,
Do you dispute that he's not entitled to the relief because of the DWI, and that that's a fine reason to have denied him that relief?
it would be, we're not attacking the weighing of the adverse factors versus the positive factors. And certainly, if the immigration judge had, simply stated, I find that this reason is sufficient alone, we would not be here today. But it was clear from the immigration judge's decision that the overwhelming factor in denying relief was the immigration judge's legal conclusion that my client had committed tax fraud. In fact, the immigration judge called it in his decision one of the most brazen or egregious cases of tax fraud that he had seen in his many, many years. Yet, and I do review this in the opening brief on pages 30 to 39. There is no indication that the immigration judges have any specialized competence in tax matters. And in fact, to the extent that, again, to draw a distinction between this case and the non-citizen, I see that I'm out of time.
Yes, your time has expired, and you've saved time for rebuttal. Thank you.
Thank you very much, Your Honor.
Ms. Juarez?
Good morning, Your Honors, and may it please the Court. My name is Yadira Juarez, attorney for the petitioner, Mr. Cuenca. As my colleague stated, this case is about the ability of the Court to review the legal standards embedded within a discretionary determination in light of Patel versus Garland, and that issued before the U.S. Supreme Court in Wilkinson versus Garland. Mr. Cuenca's challenge seemingly falls within the gambit of Patel. However, he maintains that the Court has jurisdiction to consider this issue, and asserts 3 reasons that the Board erred in denying his motion for continuance. Before I get to that, though, I would like to address Judge Elrod's question as to whether 1252 8B2I applies. And Mr. Cuenca would direct the Court's attention to the statutory language of that section, which explicitly states that only applies to claims where judicial review of the granting of relief of substantive relief from removal. That would be under 1182H, which is in the immigration world we call it 212H waiver.
Ms. Juarez, you need to speak just a little bit slower, please.
Sure. Thank you, Your Honor. The granting of relief for 42A, 42B, and adjustment of status. Mr. Cuenca contends that, well, one, he's not challenging the granting of relief, he's challenging the denial of the motion for continuance, but also that...
Patel said read it broadly. Patel says we're supposed to read it broadly. And isn't that sort of not reading it reading it in a cramped manner?
Well, for subsection I, again, point to the statutory language, which, I mean, Patel can say what it wants, but the statute explicitly says
right,
that...
but we have to follow the Supreme Court regardless of, and its treatment of the statute, in addition to just the statutory language.
Of course, Your Honor. But Patel dealt specifically with 252A2B, 2 little i's, the discretionary relief portion of the statute. And based on the United States decision in Cuenca versus Holder, 2010 decision, 21252A2B, two little i's, only applies to determinations made discretionary by statute and not to determinations that the Attorney General, him or herself, declared discretionary by regulation. In this case, it's clear, it's well established that the regulation, or that 8 CFR section 1003.29 is or authorizes the immigration judge to grant, in his or her discretion, a motion or a continuance for good cause shown.
If we were to apply the reasoning that you're advocating today, would we be creating a circuit split with the Ninth Circuit because of the Ochoa case dealing with the continuance?
Well, Your Honor, Mr. Cuenca would contend that the Fifth Circuit would not be creating a circuit split if it rules in favor of the petitioner in this case because of, like I said, Cucana versus a holder, where that determination is, it's clear that the discretionary determination is made discretionary by the regulation.
Are you saying the circuit split already exists, or that you can distinguish the Ochoa case? I'm not clear on your answer.
Yes, Your Honor. Mr. Cuenca asserts that we can distinguish his case from that case in that and I'll move to the reasons why the board erred in denying his motion for continuance. Well, first, the board misapplied its own precedent by relying on a single factor of a multi-factor analysis, which is the good cause standard. Second, the board ignored undisputed facts in the record that it could have and is authorized to take administrative notice of.
So is that the difference between, I'm sorry, I don't understand how that's responsive. I'm trying to figure out, are you trying to describe differences between Ochoa in this case, or are you trying to say that there's already a circuit split, or what is the basis of that descriptive answer? I apologize that I'm having trouble following you.
Yes, Your Honor. We're distinguishing between the case facts as to whether jurisdiction applies, which it is, or the circuits have shown that it is case intensive as far as whether that applies. For example, in Patel, that what the Supreme Court explicitly stated that section only applies to factual, well, although it must be read broadly, that it only applies to factual challenges to discretionary determinations.
But I'm asking about Ochoa. Do you think Ochoa is just wrong, and so it doesn't matter whether we're creating a circuit split, or you're talking about Patel just now, and I'm asking about Ochoa?
Yes, Your Honor. No, we're simply stating that, well, one, this case is different from Ochoa, but also in terms of the case facts, but also that, I can't speak to the Ninth Circuit decision as to whether it's wrong, but I will say that this case would fall along, I guess, those lines in terms of concluding that this court has jurisdiction based on the differentiating case facts.
Do you think it's significant here that the discretion to grant a continuance flows from a regulation and not a statute?
Absolutely, Your Honor. Yes, in Cucana versus Holder, the Supreme Court explicitly stated that just 1252A2B, two little i's, only applies to determinations made discretionary by statute, not to discretionary determinations under regulation. And there's nothing in the statute that references or talks about a motion for continuance and how to deal procedure-wise with those kinds of requests. The regulation explicitly states that provides the good cause standard for determining a motion for continuance. And this good cause standard is articulated by the board, which Mr. Cuenca is asserting the board is denying or ignoring its own precedent. In this case, is that it's a multi-factor analysis. The BIA denied or affirmed the IJ's denial of the motion for continuance because allegedly Mr. Cuenca did not provide sufficient information regarding the status of his parents' family petitions.
Why isn't that a legitimate decision on the merits under the doctrine of the matter of Hashmi, which the factors are illustrative and not exhaustive, and he only had a screenshot of a cell phone about the parents, why isn't that a perfectly reasonable determination on the merits straight up, regardless of whether or not, I mean, if there is jurisdiction?
Yes, Your Honor. Well, the Hashmi factors, the 5 factors are DHS response to the motion, whether the underlying petition or application is prima facie approvable, the respondent's statutory eligibility for the relief being sought, and 2 other factors, but they don't list anything regarding the whether there's sufficient information as to the factual update of the family petitions.
Cell phone screenshot, it's legitimate for a court to disregard a cell phone screenshot as the evidence, isn't it? And that's enough of a reason to have denied this on the merits.
Well, Your Honor,
If the parent's adjustment was a legitimate factor to be considered, the fact that it wasn't presented in a better way was within the court's discretion as well.
well, Your Honor, Mr. Cuenca did attempt to file the adjustment receipt notices at his final hearing. However, the court or the immigration judge did not allow him to submit that evidence. Seemingly the court does have a copier available, and it simply did not do that, especially because it was key evidence as to the...
We're not really saying that a court who doesn't let the people use their copier is committing some sort of error that would require overruling of the court, are we?
Well, Your Honor, the immigration judge in this case did not allow Mr. Cuenca to submit that evidence because he only had 1 copy of those receipt notices. But also, Mr. Cuenca would allege that based on Wu versus Holder, this court held that almost kind of similar fact pattern in that the petitioner in that case moved for a continuance to pursue a collateral matter, did not present any evidence as to regarding the pending family petition, and simply asserted that the family petition was pending. This court in that case determined that the immigration judge abused his discretion in denying the motion for continuance because it seemed that the denial was based on the delay of the agency to adjudicate the petition, which in this case, that was the reason why, or Mr. Cuenca asserts that's the reason why the immigration judge denied the motion. I'm out of time, Your Honor. May I finish?
No, I think you've used up all your time. Thank you.
Thank you.
All right, Mr. Stanton.
Okay. All right. May it please the court, just to make to clear one thing about the record. On page 6 of petitioner's reply brief, he acknowledges this court's precedent in the carry-on case that the hardship determinations and cancellation decisions are not reviewable. Yes, the Supreme Court may give further guidance later on this term, but as Judge Smith said, for the time being, that's the law of this circuit. But the petitioner goes on in his reply brief to say that the court has jurisdiction to consider legal questions, including this tax fraud issue, which I will get to momentarily. But and he concludes in his reply brief, asked the court to reverse the cancellation denial, but the tax fraud had nothing to do with the cancellation denial. The immigration judge, the agency, denied cancellation solely on basis of hardship, which is an element. The immigration judge did not get into the discretionary factors with respect to cancellation. That was all voluntary departure step, which is a totally different remedy. So there is just, at least for the present purposes, the court just does not have jurisdiction to review the only basis for denying cancellation of removal. And again, if that changes, the parties will certainly notify the court, and then we'll take it from there. With respect to voluntary departure, where the immigration judge did cite the tax issues, among many other negative equities, in denying voluntary departure as a matter of discretion, we most respectfully submit that the petitioner is reading too much into what the agency actually said. Yes, the immigration judge did use the word fraud. Yes, fraud can be a loaded term, but within the context of what the judge was actually doing, and you have to understand, like a lot of these immigration court hearings, the immigration judge will, give an oral decision right after hearing all the evidence, that they don't put as much thought into word choice as they may do when they sit down to actually write a decision. So within the context of what the immigration judge did here, it is clear that he's referring to tax misdeeds, shenanigans, tax improprieties, conduct, wrongful conduct. And the immigration judge gave several examples of that, like claiming the loss of extensive losses of a farm, even though the petitioners apparently had no idea what this farm business was all about. With respect to taking deductions, with respect on dependents, the nephew and the son. The son wasn't even living with the petitioner at the time, and the nephew. At most, petitioner was giving only a small amount of support, and where the tax code makes clear you can only you have to be providing at least half of the dependent support to claim before the taxpayer can claim that as a dependent. So we're really talking about conduct here, as opposed to any, term of art. But even if the tax judge, I apologize, even if the immigration judge did mean fraud, if he didn't mean what he said, that's still a factual inquiry. Petitioner insists that it's a legal inquiry, and most respectfully, the government disputes that. I do not believe this court has ever said whether tax fraud, again, civil tax fraud, there's absolutely nothing in the immigration judge's opinion that suggests he was talking about criminal tax fraud, but civil tax fraud is indeed a thing. And
But
so,
even if we could review it,
I'm sorry?
even if we could review it,
Yeah, even if you could review it, I'm assuming you can review it, but
then wouldn't it
it's a
be,
factual inquiry. So this court has never said that, but
even if we could review it,
even if we
it would
could review it,
be,
yeah, he was only talking about civil fraud.
but it's not a bad determination anyway.
Yeah.
Because that's what you're saying.
That's what I'm saying.
It's an
There
okay
was no criminal
determination.
determination here. There was, the immigration judge didn't say, well, this criminal conduct precludes you from applying for certain immigration benefits. The immigration judge did not refer the matter to the U.S. Attorney's Office or the IRS criminal authorities. At most, he was talking about civil fraud. And again, civil fraud is still a factual inquiry. Like I said, this court has never said either way, at least I couldn't find any, whether civil fraud is a factual or legal inquiry. That being said, the U.S. tax court, this probably should have been in our brief, I apologize for that. But the U.S. tax courts in Washington, D.C., I'm pretty sure that this court hears appeals from the tax court. It's all civil matters, and the tax court's actually only a few blocks from my office. DOJ Immigration, we're on Judiciary Square, and it's 3 blocks away. They have said, 15, 20, 25 times that fraud is a factual matter. And with respect to discretionary determinations, like voluntary departure, the court does not have jurisdiction to review factual determinations, even though, like I said earlier, we really don't. We really think the judge would.
Right, but even if we have discretion, claiming your nephew who lives in a different place who you're not supporting as a dependent is wrong. And that's a legitimate reason to not allow someone the benefit of the voluntary departure, isn't it?
Well,
On the merits.
It's the merits, yes. The only thing the judge might have gotten wrong, I think petitioner is basically correct that the fact that the nephew lives in Mexico is not per se disallowable.
Right, but if you're not showing that you support them in the way that he didn't support him at least 50%.
He didn't support him enough. And it's his burden. It's the taxpayer's burden just to show that that he supported him enough. The tax code actually, and I wrote it down. It's 26 U.S.C. Section 152C1D. That's the actual relevant tax provision, and it says that while yes, it's okay if the dependent lives in Mexico, you have to show. You have the burden to show that you were providing for more than half of the dependent support for a tax year. And there were some years here where he didn't provide any support at all for the nephew, but still continued to list him as a dependent. So, I mean, so to the extent this court can review it all, again, we respectfully submit that it cannot. I mean, the judge was ultimately correct that this was improper. So, I mean, and again, the farm, like I said, and as the immigration judge said, he kept on doing these things even though he was already in removal proceedings with the judge. I mean, the judge said you should have been on your best behavior, but you still continued to do things the IRS told you was impermissible. And so, and
Could they
he claimed-
Could they deny voluntary departure because he got a DWI and was driving without a license?
Yes, several reasons, Your Honor. Yeah.
And letting his son drive without, who's not qualified to drive, and all of that as well. Were
Sure.
those all legitimate
Yes,
reasons?
there was
to
several
deny?
very strong negative equities. So it wasn't just the tax issue; it was also the DUI, and also the fact that he was permitting his son, a minor, I mean, to be put in dangerous situations by having people, himself, his wife. I'm sorry, not his wife, his the mother of his son, transport the son places without a valid driver's license, and those were. It wasn't so. It was not just a tax issue. So there were several reasons why the immigration judge denied voluntary departure as a matter of discretion. And in all likelihood, even without the tax issues, that would have been enough to deny voluntary departure as a matter of discretion. So, anyway, but with respect to continuance, we did cite the Ninth Circuit's decision in a footnote, and I very much apologize to the court. I prepared the merits for the continuance issue. I did not prepare the jurisdictional questions. That being said, I will submit that the court has an independent obligation to determine its own jurisdiction before addressing a matter. So, and we would submit the Ninth Circuit reasoning was sound. We would encourage this court to review it, and if the court agrees with it, by all means, we would encourage the court to follow it. And again, if there's something new coming out of the Supreme Court affecting discretion, we will be sure to let the court know immediately. With respect to the merits, I mean, there are two elements where petitioner has to show to get a reversible denial of a continuance. There's abuse of discretion with respect to good cause, and there's abuse of discretion with respect to prejudice. And most respectfully, petitioner does not focus at all, does not address at all the prejudice element. Prejudice under this court's precedent, the court has said several times in unpublished decisions. One of those came out in 1993, the Ikifa case. I'm having trouble pronouncing it. That's a presidential decision, and petitioner has to show that the ultimate result in this case would have been different. It's not enough to show that the parents might have been granted adjustment of status. He has to show that his case would have been different, and he does not do that at all. Doesn't make an effort to do that. He hopes to get his parents to be additional qualifying relatives for cancellation of removal purposes. But the immigration judge, in his opinion, I believe it was on page 88, 89 of the administrative record, gave several reasons why these parents just don't qualify. He didn't give any objective proof of his parents' infirmities. I mean, the court in Penn, which is in the Pan case, that decision that we cite, I mean, upheld the denial of continuance for pretty much the same reason. It's not enough for the petitioner to say, hey, my parents are in bad shape. He has to produce medical records, affidavits, testimonies, some sort of objective proof to that effect. He also doesn't address the fact that because his brother, who is a United States citizen, served as the sponsor for the parents' adjustment of status applications, the brother guaranteed that he would financially support the parents. So petitioner never explains why his presence in the United States is necessary to support his parents. I mean, he said his parents also, his mom apparently twisted her ankle falling down. His dad's got a bad vision in one eye, and his dad also has diabetes, type 1, type 2. I don't know. He doesn't say. I mean, those things just are not the type of things that would reach the standard necessary for exceptional and extremely unusual hardship for cancellation of removal purposes. So there's just no prejudice in that regard. Even if the immigration judge had granted the continuance and allowed the parents' adjustment of status applications to go forward, the ultimate result would have been the same. He would not have qualified for cancellation of removal. With respect to his own adjustment of status application, the short answer is, I mean, the exact same discretionary determinations that led to a denial of voluntary departure would have been applicable to his adjustment of status. I mean, if anything, it would have been a harder sell for adjustment of status. Voluntary departure allows you to leave the country on favorable terms. Cancellation removal, I mean, allows you to stay in the country. So it's, I mean, never say never, but if you've been denied voluntary departure as a matter of discretion, it's a very, very, very uphill fight to argue that you have gotten a favorable exercise of discretion with respect to adjustment of status. Again, he has the burden to show the result would have been different for prejudice. He does not do that. With respect to good cause, I mean, Judge Elrod, you made the same points I was going to make. He simply did not show enough to the immigration judge to justify the good cause standard. I mean, he relies heavily on the Hashimi decision, saying that good cause should generally be granted when there's been even when there's a pending visa application. 2 sentences later in that opinion, the board and Hashimi also says it should not be granted in every circumstance. And number 2, the most important thing to look at is the likelihood of success for the adjustment of status application. At the removal hearing, I'm sympathetic. Mr. Bray said like he was told this the morning of the hearing by his clients. He didn't have the adjustment applications ready. And so, I mean, the immigration judge just had no way to evaluate the likelihood of this success with the parents' adjustment of status applications. I mean, that's the focus. I mean, according to the same Hashimi decision that he cited, and with respect to his own adjustment of status application, he never filed an adjustment of status application at all. So, and the way we read this court's decision in Silva Rosa, we're talking discretion for continuance, and this court suggests in Silva Rosa that discretion ends when the non-citizen has a vested right in an adjustment of status application. And the way we read the court decision, you have to fill out the necessary steps. I mean, apply for petition approved, a visa has to be available, and you have to actually apply for adjustment of status. And all that's left is for like a bureaucratic stamp to approve the adjustment application. Then discretion ends, and yes, continuances should be granted. As almost, I want to say, a matter of right, but I mean, it's possible. There may be some circumstances where, I guess there could be, like, if there's a disqualifying criminal conviction. But bottom line is, whatever it is, the right to vest certainly had not taken at this point in the proceedings, and so I mean. So there's just no abuse of discretion here, which is, again, a very, very, very high standard. And again, if the Supreme Court comes back with some new guidance, we'll be sure to let this court know immediately. I've said all the points I wish to make. If there's anything this court would like to ask me.
All right, thank you, Mr. Stanton.
All right. Okay, thank you.
Bray, you've saved some time for rebuttal.
Thank you very much, Your Honor. I just have a couple of short points for rebuttal. Firstly, I'd like to highlight that in Patel, the immigration judge in that case did have a special competence concerning the nature of the allegation of fraud, which was immigration fraud related to citizenship. Whereas in this case, the immigration judge lacked any sort of special competence concerning the nature of the fraud, which was tax fraud. And again, tax matters are complex, and it's a different area of law, and was outside the jurisdiction of immigration judges, which is defined by regulation and also by the statute at Section 240 of the INA, Section 1229A of 8 U.S.C. So concerning the issue of tax fraud, just one more point I wanted to make about that, Your Honors. It is not in dispute that Mr. Cuenca did in fact send money to his nephew in Mexico. I believe that there was some confusion on that point, but in order for my client's nephew to qualify as a qualifying relative under IRS guidance, there had to have been some sending, financial support to the nephew, and that is clear from the record. It's the record on appeal, page 182.
But you're not saying he sent it in every year that he claimed this, which would be required. So you're not actually saying he did what he needed to do under the tax code, are you?
Yes, Your Honor, that is.
Doesn't he need to send it in every year that he's claiming this?
What is apparent from publication 501 of IRS guidance is that there has to be continued financial support, and there was, testimony about that, and was not in controversy.
Aren't there years that he didn't send anything? That he claimed him as a dependent?
That's not clear to me.
That's not in the record?
I don't recall seeing that in the record, but what I do recall seeing is that on page 182 of the record, it does clarify that. If I may just make one final point very quickly.
Yes, you may.
Thank you very much, Your Honor. Concerning the issue of hardship, my client's brother had intended to testify and was going to testify, but the immigration judge refused to allow his testimony because the brother went outside the courtroom to pay parking, and then when he came back in, was not allowed to testify about the hardship. So I just wanted to make that point. And with that, I'll rest. And thank you very much, Your Honor, for your time.
Thank you, Mr. Bray. Your case is under submission.